report back on the record. This is the beginning of tape number 6 of the due process hearing for Crossett versus Jordan School District matter. The time is 8:27.
Go ahead.
Thank you. Mr. Evans, in going over your testimony this afternoon, you clearly indicated that if a child was out of a school district for over 10 days, they're out of school. Is that correct?
By Utah law, if they're out of school for 10 days, they have to be withdrawn from school, so that we can't count them in attendance.
So is it your testimony that a parent who takes a 2-week vacation with their child, the child has to be reassigned to a school and that they basically have to re-enroll?
No.
Well, maybe you could explain the difference between the two things that you just said, that after 10 days they're out of the district, and yet they can take a 14-day vacation, and they're not out of the district.
Yes, 10 days of unexcused absence. If they take a 10-day vacation that has been approved with their school, there is a provision for that to allow them to take work and come back to the same school.
So there's contingencies to that 10-day rule. Would that be a correct statement?
If there's 10 days of unexcused absences, a student must be withdrawn by Utah state law.
Is that 10 days out of the district or 10 days that they're not in attendance at school?
10 days that they're not in attendance at school.
Are there any other contingencies for having them withdraw from school after 10 days?
Is your question, are there any other circumstances in which a student could be out of school for 10 days and still be enrolled when they come back?
Yes, please.
Yes, there is.
Would you name them, please?
Home and hospital services.
You also tested this afternoon that your school district provides federal money from the IDEA program to 504 handicapped students. Is that correct?
That's incorrect.
Is it incorrect that you testified that way, or have you gotten information since then?
It's incorrect that I testified that way.
That's not my question.
Yes, it was.
No, it isn't.
Maybe.
I ask additionally if you received additional coaching or counseling and or additional information. Your testimony was clearly indicated that you give IDEA federal monies to 504 handicapped students.
Objection, it's argumentative. Witness has answered the question to the best of his ability.
Well, I'm trying to understand the distinction. What, can you explain our confusion? Or should we ask another question?
The question, as I understand it earlier today, is it possible for 504 students to receive special education services? And the answer to that question is yes, it is possible for them to receive those services. The second question is, do they receive IDEA funding for those services? And the answer to that is that the IDEA funding is to be supplemental, not supplanting, and so generally the special education services that a 504 student would receive would not be IDEA services.
Your Honor, before you make a ruling on this, may I just interject here that the testimony is extremely clear this afternoon that this gentleman, who is the compliance officer of the Jordan School District, indicated that IDEA funds, federal funds, were used for 504 students. That was his testimony. And now it appears he's changing his testimony because he's had time to counsel with other people that that's fraud. You can't use federal monies for 504 students. He didn't seem to know that.
Is there an objection on the table? Because I asked for a clarification. I think I'm clear. about what Mr. Evans' testimony is. And I don't recall this afternoon if he specifically said funds were used. I thought the question was, as he stated it, do 504 students receive IDEA services
Special ed, sir.
or special ed services? But in any event, I'm not sure, I mean,
Well,
help me
you're-
figure out how this is important to the issue of evaluation of your daughters and their eligibility under 504 or IDEA.
Well, it's important on credibility. Does this man really know what he's doing? Does this man really understand the difference between 504 ADA and IDEA? His testimony doesn't seem to indicate that.
Okay.
What are 504 students entitled to from the school district, Mr. Evans?
They're entitled to reasonable accommodations or other supplementary aids and services as determined by the 5014.
Were you told that between this afternoon and this evening?
No,
So you know that to be a fact before this hearing started?
that's correct.
Would language be a 504 handicap?
I believe the term that they use is disability.
Okay, you could
I'd go.
insert your own term there if you'd like to, disability. Is language a disability under 504 Rehabilitation Act?
Yeah, an eligible student must have a disability, yes,
I don't think that's responsive to the question that I asked. I simply asked if language alone is a 504 disability.
You need to specify
Well, let
your
me ask a question,
definition of language.
because there is a relevant question there that I'm curious about as well. Is an inability to speak English considered a disability for under 504 or IDEA?
It is not.
Okay.
So let me see if I understand what the judge asked you and what you just said. The inability to speak English under 504 regulations is not a disability.
That would be correct, yes.
You're not familiar with the 1974 Nichols Supreme Court decision that language is a disability?
Objection, the witness is testifying, or the,
Well, he can answer the question.
That would be, define what language in that case was.
Children who cannot speak English in a public school system in the United States were determined by the Supreme Court of the United States to be handicapped.
I would say not within the meaning of 504 or IDEA. The number one compliance issue with 504 is disproportionate representation of minorities in disabilities. They are the primary government agency that enforces that issue, and they require us, it is the Office of Civil Rights that requires school districts to certify that it is not language that is the student's primary problem in education before we can consider a disability.
Are you sure you're not confusing the IDEA law that language cannot stand alone and be the determining factor with the 504 law that basically says if a person is considered handicapped, suspected being handicapped, etc., that they're qualified under 504 for accommodations? Are you sure that you're saying exactly what you mean to say?
I am saying that a student is not disabled simply on the basis that they are, that they do not speak English as a first language. Yes, that's what I'm saying.
Okay. Did you have a conversation about your testimony from this afternoon?
No.
Would you consider that the procedural safeguards that the district has promulgated are reasonably understandable to the average parent?
I don't believe that they are.
Can you expand on that, why it wouldn't be?
I think that it's a higher reading level than most people have.
Would it be higher than a master's degree?
Depends on how well the person reads that got a master's degree.
Well, considering that the statistic is 99% of the people in the entire world never had a master's degree, wouldn't it be reasonable to assume that a master's level person might be able to interpret the safeguards that have been promulgated by the state of Utah?
It would be reasonable to assume that they might be able to, yeah.
Would you mind reading for the court out of your own procedural safeguards, section C?
Objection, the reading of the section is cumulative testimony at this point. With respect to his understanding, I don't have an issue, but as far as actually reading it aloud, I'm not
Have we
sure if
already,
that
have we
gets us
already heard
further.
it? Is this the one we've already heard, or is
Michelle
this?
Peterson, correct.
Your Honor, I certainly have a right under IDA law to challenge the educational level, the competence, and the ability. This man just testified,
Well, you need to finish that sentence, though, I think. Of a service provider, sure.
okay? And he obviously was involved in my children's rejection of services because he's the compliance officer. He is basically the agent of the district. He provides and promulgates the rules, the regulations. He's testified that he's read the federal and the state regulations, and he just testified that basically at his level, he should be able to understand.
Well, if you have, I think counsel's point is we've already had this section read, if it's the same section that the principal read. If you want to ask him a question about it, great, but I'm just trying to save us time from having the same thing read again. He could read it to himself and you could ask him a question about it.
All right, would you read section C? And then my question is, what does that mean?
And just for the record, which part are you reading?
This is regarding the notification, written notification of, for parents of a meeting.
But what's the site?
It's
I believe these are the procedural safeguards.
procedural
That the
safeguards,
district distributes.
due process for parents and children, subpart E, it's
Oh, so this is,
C.
okay, so this isn't part of
On
the reg,
page
this
4.
this is the district procedural safeguards handout.
That's correct, yeah, it's basically the state's
Got it,
procedural safeguard.
thank you. Go ahead. While he's reading that, Mr. Cressett, do you have a site for that Nichols case?
Yes, I do.
Just when you come up with it, I just wanted
Okay.
to take a look at it. So. Sorry, if you're ready, Mr. Evans, I don't wanna.
Is the question, what does it mean?
Yes, please.
Basically, the parent is part of the IEP team that makes decisions about children, and they need to be notified of the meeting early enough to ensure that they're able to attend, and it needs to indicate the purpose and who's going to be at the meeting.
Have you seen what the procedural safeguards are in the federal regulations compared to that 182-word sentence that you just read?
They're very similar to this procedural safeguards for the feds. I believe this was taken right from it.
Is that your testimony, that you've read it and you understand the difference between how the federal regulations require procedural safeguards and how the state of Utah wrote it?
I believe that the state of Utah wrote this because they were required to by the federal auditors.
And it's your testimony that that pretty much follows the procedural safeguards of the federal regulations?
Yes.
Here's the federal regulations, procedural safeguards. Is that your testimony that the state of Utah made up that 182-word sentence?
I would like to see the document before the witness answers
You've had the
questions.
document, counsel.
I just need to know what it is, though.
This isn't the same. Those are procedural safeguards, but there is a paragraph in it. I'd have to do an analysis of it, but that's this area that if this is what you're talking about, that you've highlighted here, is this what you're talking about?
Well, I'm talking about the comparison of a 182-word sentence in the state of Utah code compared to the federal code, which I don't see any sentence there over probably 10 or 12 words.
I'd say that this is required by the feds. You'd have to ask the state office, but I can pretty much, that would be my testimony that this was required by the federal auditors.
And that's clear and understandable to you.
It's clear and understandable to me.
Would it be your testimony that that would be clear and understandable to a parent who received the procedural safeguards?
It would depend on their ability to understand and their reading level.
Well, we certainly know that 99% of them wouldn't have a master's degree now, don't we? The record should show that the procedural safeguards that the state of Utah made up off of the federal regulations don't even come close. They're arduous, they're an artificial hurdle. We've had 2 master's degrees here, both of them can't understand them. And they're made for average parents, aren't they, Mr. Evans?
They're given to all parents to notify them of their procedural safeguards.
But I didn't get them, did I?
I don't know if you got them or not.
Well, your testimony this afternoon, perhaps it'll change as the hours go by. You indicated that the safeguards are given in the Jordan District after the due process has started. My question basically is, how would a person know how to initiate the due process if they don't
Objection.
have?
Asked and answered, same question.
Excuse me,
from earlier.
you're interrupting me. Could I finish the question, Your Honor, and then have her interrupt?
Just finish the question.
Thank you very much. You indicated that it was a Jordan School District policy to give the procedural safeguards after a parent entered into the due process hearing. Is that correct?
That's not correct.
It's not correct that you testified that way, or it's not correct that you don't give them? What do you mean when you say that is not correct?
Your question this morning was, why did I get these after I had initiated the due process hearing? And my answer was that is probably when you were identified as a person that had standing to receive the procedural safeguards. Parents that are involved in IDEA issues are parents that receive the procedural safeguards.
So it's your
parents
testimony,
can
I'm
be
sorry.
Parents can be given those procedural safeguards at different points, at different times in the process, the IEP process. They're available at school, available at the district, at the state, various places around the community.
What does the IDA law mandate for giving those procedural safeguards to parents?
When the the district or the parent initiates or propose to initiate evaluation and placement of a child with a disability.
Doesn't that conflict with just exactly what you said a few minutes ago?
I don't see where it does, no.
Let's go back to the knowledge you have of Black's definition of a residence. Is it your understanding, as the compliance officer of the Jordan School District, that a parent can have more than one residence?
It's not my understanding that you can have more than one primary residence, no.
I'm sorry, I didn't use the word primary. I specifically said an additional residence or more than one residence.
Not within the district, there's one identified residence.
So it's your testimony that if a parent has a vacation home or other kind of residences throughout the country, they're not allowed to have special education services in Jordan District?
No, that wouldn't be my testimony. They can have vacation homes and at their discretion.
Well, you use the term permanent. As the compliance officer, part of your job is to determine residency, isn't it?
Mm-hmm, that's correct.
So what would a permanent residence include to be a permanent residence?
That would be the place where an individual resides for the majority of the time.
So you're saying that a person to have a primary legal residence has to be in that home more than 51% of the time?
Not a particular percentage, because a person could move within the school year to a different residence.
Well, your testimony indicated the word majority on a standardized curve, which you're familiar with, and the mean, it would have to be more than 51%, wouldn't it?
And, I think it depends on the facts of each individual case also.
Then could you give the court a clear definition, as the compliance officer with a master's degree, what is and what are the requirements to have a permanent residence for the Jordan School District services?
That an individual owns a residence within the district, resides in the residence, and the child is present.
Well, Mr. Evans, isn't it true that the residence doesn't even have to be owned?
Oh, they could be, you could be a rental property too.
It certainly could, couldn't it? It also could be a parent or a child living with a relative within the district too, couldn't it?
Under certain circumstances.
So your original statement wasn't totally true, was it?
What was the original statement?
You indicated that a person had to purchase a home within the district.
Oh, yeah.
Objection,
that
it's
wasn't-
argumentative.
Sustained.
Yeah, that wasn't totally. Person could rent a home, and we do have some rentals in the district.
You also have some leases, don't you?
I'll bet we do.
So as the compliance officer, you're basically saying that a residence is where a person intends to live or does live? Can you just clarify that just a little bit, please?
It's where they do live.
Is it your understanding basically that the special education services under IDEA are restricted basically to the state of Utah? That they do not go outside the state of Utah?
I want to object to the extent that this line of questioning was fully explored this morning. I'm not sure that it's precisely an asked and answered, but I would question the relevance.
Well, Your Honor, the relevance is that this district has said that my kids are out of the state of Utah, therefore they're not qualified for special ed services. I'm simply asking the compliance officer, can they receive special ed services outside the state of Utah, yes or no?
Answer that question, yes or no, if you can.
Well, every state in the union must provide special education services, so they could receive special education anywhere in the United States,
From the state of Utah.
not from the state of Utah.
So when does the special education responsibility of the Jordan School District end?
When a student, the state is responsible for child find and provision of services for students that are in the state of Utah by IDEA standards, by the state law within the district of residence. And so when they move out of the state of Utah, they're no longer eligible for those services.
So is the answer to the question, when they move, that's when the services basically are exhausted?
When they move out of the state of Utah, then the other state that they move to is responsible for those services.
When you use the word move, are you talking about their permanent residence?
Yeah, basically, the place where the student is generally considered the student's residence.
If a student is under the age of 18, can they legally have a residence established by themselves?
Objection calls for a legal conclusion.
If he knows, he can answer.
If they're an emancipated minor,
What if they're an unemancipated minor and under the age of 18?
they can be a resident of wherever a person that is a parent under IDEA or a guardian has been assigned, or another parent.
Are you familiar that the IDEA federal regulations defines exactly what a parent is?
I am.
Could you go over what your understanding of that is, please?
It's a parent, a person acting as a parent, a surrogate parent or guardian.
When did you learn that?
That was
You're under oath, just asking when you learned that.
it's hard to say.
Well, take your time. It's an important question.
Probably in 1974.
The IDEA law of 1974,
It was then called the Public Law 94-142.
and your testimony is that that section under definition of a parent was in that document?
That's correct.
So if a person under IDEA rules of a parent is living with a child, does that qualify him legally as the parent?
If they're a person acting as a parent and if they're living with a parent, yeah, I would say that would be their parent, yeah.
What if they're living with a relative?
If the relative is if the parents have released them to the relative to be their guardian, then they could also, under state law, act as a parent.
So it's your testimony basically that the IDEA doesn't require a legal adoption to be a parent under federal rules, does it?
That's correct. You don't have to have you can be a person acting as a parent.
So a legal adoption isn't necessary?
To be a person acting as a parent, no.
Thank you. That's an important.
It's not the time for closing arguments, Your Honor.
I'm not making a closing argument. I'm making it.
Okay, you don't need to
Statement.
talk to one another. Let's ask the witnesses questions.
Is IDEA federal money that Jordan School District basically receives?
Yes.
Do you know what a presidential executive order is?
No, I'm not sure what that is.
Are you familiar with how a presidential executive order stands in relation to the law of the United States?
I'm not.
Have you read the executive order of President Clinton, number 13160?
It doesn't ring a bell.
Well, Your Honor, would you like me to read this, or is it possible that the witness, since the witness,
If it's relevant, you're gonna ask him about it, why don't you let him read it?
thank you.